I'm honored to welcome back to Chautauqua our good friend John Q. Barrett. Professor Barrett is the Benjamin N. Cardozo Professor of Law at St. John's University in New York City, where he teaches constitutional law, criminal procedure, and legal history courses. He's also the Elizabeth S. Linné Fellow at the Robert H. Jackson Center. Professor Barrett is writing a biography of U.S. Supreme Court Justice and Nuremberg prosecutor Robert H. Jackson. This work will include the first inside account of Justice Jackson's service by appointment of President Truman as the chief prosecutor at Nuremberg of the principal surviving Nazi leaders following World War II. Please help me give a warm Chautauqua welcome back to Professor John Q. Barrett.
Thank you so much, Shannon and Chautauqua and the Robert H. Jackson Center and Arnie and Jill Bello, whose family fund adds support to this lecture. This is a high privilege for me. It's my 25th consecutive summer of getting to speak on one Chautauqua platform or another. And it's a privilege to get to welcome the 21st annual Robert H. Jackson Lecturer. I will speak briefly about Jackson, about the lecturer and the lecturer, and then the main attraction will be spectacular. Robert Jackson was you. He was from here. He was from a little south of the state line, but grew up in this southern tier of New York, and he was a Chautauquan. He was in the audience and in time was at the lecture platforms, and a lot of his general higher education was acquired here on these grounds because he never went to college for a day in his life. His life ran from 1892 to 1954. 62 short years by our standards, I assure you. He was born on a farm in Spring Creek, Pennsylvania. He grew up in Frewsburg, New York, which is south of Jamestown. He came to Jamestown for a second senior year of high school and then stayed there as a law apprentice, going to the Albany Law School for 1 year, becoming a young solo practitioner Jamestown lawyer at age 21. He then spent 20 years in private practice, moving from Jamestown to Buffalo, back to Jamestown, and rising to be a leading legal figure in New York State and indeed in the nationwide American bar. His practice was trials and appeals, was transactions, was corporate advising, was board work, was civil and criminal, a kind of general law practice that one could not do today, I'm afraid, but in his day made one truly a lawyer for the situation. He also was a Democrat, and in the 1920s, an early acquaintance ripened into political support for gubernatorial candidate Franklin D. Roosevelt. And when Roosevelt became governor in 1929, Jackson was a supporter, a volunteer, appointed to various task forces and projects, a proxy speaker in the 1930 re-election campaign, a supporter of the 1932 presidential campaign, and thus an opportunity to join the New Deal. In the next 7 years, Robert Jackson rises through high executive branch offices. He is nominated by Roosevelt and confirmed by the Senate 4 times in a 7-year period. In 1934, he is confirmed and serves as general counsel of the Bureau of Revenue in the Department of Treasury. IRS General Counsel is what we would call it today. He's detailed from there for a year, sort of off to the side, to the Securities and Exchange Commission. In 1936, he's confirmed to be an assistant attorney general. He first, in the Justice Department, heads the antitrust division, the tax division for a year, and then the antitrust division for a year. In 1938, he is confirmed to be the Solicitor General of the United States, the government's principal advocate in the Supreme Court of the United States. And over the next 2 years, he argues more than 40 cases, quite brilliantly, before the Supreme Court. In 1940, he is confirmed to be Attorney General of the United States, the top of the U.S. Department of Justice. And in that 18-month stint heading DOJ, much of his work is war preparatory legal issues, as the isolationist but Britain-aiding United States looks across to this European war. In 1941, he is nominated by Roosevelt and confirmed by the Senate for the 5th time to be an Associate Justice of the U.S. Supreme Court. And he is only 49 years old when he has achieved that position. He spends the next 4 years as Justice Jackson, the second in his day, today the third, with Justice Ketanji Brown Jackson, carrying on the surname quite brilliantly. Jackson's work during the 4 years, 1941 to 1945, establishes the Justice Jackson voice and stature and approach. He's a beautiful writer. He is quite autobiographical and doesn't hide his cards as he works his way through cases. He is a case-at-a-time jurist, not particularly ideologically pre-committed to this or that type of litigant. He votes, he takes stances, he leaves opinions that turn out to be enduring monuments. For example, his opinion in Edwards versus California, his first opinion defending the rights of the poor, the Okies who were immigrating to California. He is an early concurring opinion author of maybe the landmark that establishes modern reproductive rights jurisprudence in Skinner versus Oklahoma, a forcible sterilization of an incarcerated man case. He is an author of a liberty of conscience opinion that is very prominent and permanently significant. West Virginia Board of Education versus Barnett, which was about Jehovah's Witness school children who had religious scruples against bowing down before a graven image, saluting the American flag, and pledging allegiance. And they were suspended by their school, and their parents faced prosecution for the children being truant. And in wartime, the U.S. Supreme Court struck down that state imposition of mandatory patriotism. And Jackson authored in 1944 a notable, albeit dissenting, opinion about the constitutional limits on executive and particularly military power to persecute based on nationality. His dissenting opinion in United States versus Korematsu, the Japanese-American exclusion case, which sadly 6 justices were on the top side voting to uphold that military policy. And then in 1945, he goes AWOL from all of that for a year. He gets his 5th presidential appointment. President Harry Truman now appoints him to represent the United States as the chief prosecutor of the principal surviving Nazi war criminals, the job that becomes Nuremberg chief prosecutor. And he does that job, and he is immersed in that work and those topics, and frankly, that evidentiary discovery process for an 18-month period. He returns to the Supreme Court in 1946, and he serves there for 8 more distinguished years. Those are Cold War years. Those are presidential power and military power challenge years, where individual freedom is again in the crosshairs. Those are case years facing racial equality. What we had fought and defeated in Imperial Japan and Nazi Germany was, of course, in lesser forms, American segregation and racial subordination in this country. And Jackson is part of the court that's dealing with that in the late 40s into the early 1950s, and he's part of the 9 who unanimously decide Brown versus Board of Education. In other words, it is a life and a menu of high responsibilities with law, liberty, and power in monumental, enduringly significant times. Thus, my second topic. Chautauqua Institution has this lecture named after and honoring the achievement of its son and this life, and particularly the Supreme Court part of his work. This started 21 years ago. It occurs during, of course, the summer. Here we all are, which is the Supreme Court recess and is a good opportunity to take stock of what the court is, what the court's done recently, what the court is becoming, and what constitutional law and government are now in our life. And so part 3. Chautauqua attracts to give this lecture every year an extremely erudite, prominent, eloquent, fun lecturer, and you're about to meet one. This year's lecturer is Kim Lane Scheppele. She is a graduate of Barnard College. She earned her master's degree and her PhD in sociology at the University of Chicago. She earlier in her career was a professor at various fine universities and colleges, including the University of Michigan, the Central European University in Budapest, and the University of Pennsylvania Law School. Since 2005, she has been the Laurance S. Rockefeller Professor of Sociology and International Affairs in the Princeton University School of Public and International Affairs and the University Center for Human Values. Kim's research and scholarship focuses on the rise and fall of constitutional government. She writes prolifically, including now online at The Contrarian. I encourage you to watch and Google and gather up lots of her work. She is currently writing a book called Destroying Democracy by Law, which will be published by Harvard University Press next year. And it is a very high honor to welcome as this year's 21st Annual Robert H. Jackson Lecturer on the Supreme Court of the United States, Kim Lane Scheppele.
They put up a little thing here so I can see you because I'm short. And I'm also, I'm delighted to be at Chautauqua. This is such a legendary place. It's also a legendary lecture. And it's named in honor of a legendary figure. And I should say, because John Barrett is such a modest guy, I sometimes feel like when I'm talking to him, I'm in the presence of Robert Jackson, because he actually, I think, knows more about Robert Jackson than Robert Jackson may have known about himself. Because as you know, like if you're 35, you don't know who you're going to be when you're 45. And if you knew, you would think differently about yourself. And he knows all of that about Robert Jackson. So, I feel like we're here in the presence of the best living expert on Robert Jackson. So it's a little intimidating to give this lecture, and he'll correct me if I've made a mistake talking about Jackson today. I should also say that the lecture I'm about to give has an invisible co-author, because the project, the sort of written paper that's going to be coming out of this lecture actually does have a co-author. And my co-author is Andrew Weissman from NYU Law School. Some of you may know him from MSNBC. Great. He'll watch the video, so thank you for the applause. Also, his podcast, Main Justice, with Mary McCord, is just a terrific explainer of the week's legal news. And so he and I independently arrived at some of the ideas that I'm going to talk about today, and now our ideas are so intertwined because we've been doing this on the road as a kind of two-for conversation that I can't tell what's mine and what's his, but he can also disown some things that I'm saying that maybe he hasn't heard of. But anyway, he's the invisible co-author here, and I just want to say that being invited to give the Jackson lecture was also an opportunity for me to do a kind of deep dive into Robert Jackson. And so the first half of my talk today is going to be about Jackson and about his time and about some of his ideas. And the second half will be about now. Okay, so stay tuned. Now, when I was asked to give this lecture, the Robert Jackson lecture on the Supreme Court, the first thing I said to John was, I don't talk about the U.S. Supreme Court. And the reason why I say that is that I actually stopped teaching U.S. constitutional law after Bush v. Gore. I was involved in that case. I was in Florida. I would have handled the legal aftermath if the court had decided something differently. But it was the first time, really, that the Supreme Court made a decision that was just impossible to justify on the basis of its pre-existing law. And I must say I have a kind of low tolerance for decisions that don't have enough law in them. And so I literally stopped teaching U.S. constitutional law. And that's the beep. So anyway, so I don't usually talk about the court. Instead, what I did was I've shifted to writing and talking about the constitutional law of other countries. So, and after the Berlin Wall came down, I moved to Hungary. I worked at the Constitutional Court there for 4 years. Moved to Russia, worked at the Constitutional Court there as democracies were being built up. And it was an optimistic time. And now, if you know about what's happened first in Russia, then in Hungary, and in a number of other places, constitutional democracy is a bit on the ropes. And so I followed it up the escalator and down. And that's really what I've been teaching. And that's why I'm going to talk about Jackson, and then I'm going to talk about now, because I have been actually teaching Robert Jackson every year. I teach a course on the rule of law, and the opening reading that I make all of my students read every year is Robert Jackson's opening statement as the Nuremberg prosecutor. If you're going to read something while you're here, Chautauqua was famous for sitting under the trees and reading. Read Jackson's opening statement. Not only is it beautiful prose, but it lays out the evidence against the high-level Nazi leaders. And it lays out the case for the rule of law. And I really urge you to read it. It's the thing I think that has inspired a lot of the work that I've done. And so what I'm going to do is to pivot around Robert Jackson's experience at Nuremberg. Because today, when the fate of American democracy is in the balance, I think Jackson's experience at Nuremberg has something to teach us. And so let me just foreshadow what I'm going to do. I want to convince you today of two things. One was that the Nuremberg trial and Jackson's participation in it had a major effect on him, and through him had a major effect on US constitutional law, particularly on the doctrine of separation of powers in the Youngstown case, which was the case involving the seizure of the steel mills in order to keep production going during the Korean War. That framework that Jackson laid out in that case has been the dominant framework that the Supreme Court has used for thinking about separation of powers ever since that case came down in 1952. However, fast forward to last year, and those of you who are repeat players and heard Kate Shaw's lecture last year knows that she spent her lecture talking about Trump versus the United States, which was the case the Supreme Court decided last year that awarded a very broad swath of immunity from criminal prosecution to any actions that a president would take while in office. And in that decision, which I'll try to show you today, the Supreme Court cites Jackson, but they completely obliterate the concurring opinion he wrote that has shaped separation of powers. And so the framework that we've used to protect American democracy since Jackson's opinion is now gone. And the question is, where are we now? And I'm going to talk to you about that. And because Jackson changed his mind about separation of powers and how it works through his experience at Nuremberg, one thing I want you to think through with me is that maybe if we also look abroad in this moment, we find both cautionary tales and hopeful tales about what we do from here. So that's where I want to go. So first of all, let me pick up Jackson's, you've heard Jackson's story. What I want to focus on is when Jackson becomes a government lawyer, when he goes to Washington, and working under Roosevelt, whom he admired greatly, he repeatedly argued for the expansion of executive power to handle the crises that the US was facing at that time. So one thing I was actually surprised to learn, and kind of going back through the record, was many of you may recall, all of us from history books, that when Roosevelt became president and got Congress to pass a whole bunch of legislation to deal with the economic crisis that was the New Deal and its aftermath, the Supreme Court blocked a lot of what they did. The Supreme Court, one case after another, found the New Deal legislation to be unconstitutional. And Jackson was, thought the president, we should be able to enact this plan. This is what Roosevelt ran on. This is what the Congress has voted for. The Supreme Court was an obstacle. And so Jackson became one of Roosevelt's leading defenders in the plan to expand the Supreme Court to add more judges to be able to change the results. The court packing plan, right? And Roosevelt's plan was to say, well, look, there are all these elderly judges on the court who were 70 and older. Okay, so I can tell, many of you perhaps, but 70 and older, and Roosevelt said that people over 70 don't have the energy they used to have. So they need extra people on the court. For every judge over 70, we're going to add a judge just to make sure they can handle the workload. That was Roosevelt's plan. Jackson defended him. He gave 5 speeches in favor of the court packing plan. And he argued that this was because the court was out of touch, okay? And he said, and this was in testimony before the Senate, which was really very influential testimony before the Senate as he's trying to get the Congress to pass the law that would allow Roosevelt to pack the court. He says, the framers, quote, never thought when they spared words in the interest of simplicity that we would reach a point where nothing is lawful unless the Constitution has a word for it. In other words, the court was making stuff up, right? They weren't sticking to the words of the text. He said, we cannot outlaw every action that cannot show a precedent. Okay, he's like really leaning into it. He gives this speech before the New York Bar Association in January of 1937, where again, he's trying to enlist the bar in this, this project of packing the court. No administration can halt its policies dealing with such problems as a banking emergency, unemployment, relief, or the currency to seek the judiciary's view. The government cannot learn the judge's view until after a law is passed, and then only after a lapse of years as the view is slowly made available in private litigation. In other words, we got to act fast. The court slows us down. Moreover, he said, the judicial contribution is only a negative. It may tell what cannot be done to right a wrong or solve a problem, but it can never tell what can be done. In other words, all the court is doing is slowing down the solution of problems for which we have this crisis. We were voted in to be able to solve these problems. He writes a book called The Struggle for Judicial Supremacy, which he publishes in 1941, just before he goes onto the bench. I can imagine his colleagues, when they read this book, think the whole book is an attack on the Supreme Court, okay, including many of the colleagues he's about to sit with on the bench. And in this book, in the preface, he says, for a century, every contest with the Supreme Court has ended in evading the basic inconsistency between popular government and judicial supremacy, right? And then he says, in no major conflict with the representative branches on any question of social or economic policy has time vindicated the court. This is the court he's about to join, right? So he's like all into kind of trashing the Supreme Court. But then he says, look, we're not trying to interfere with law, with the rule of law. Okay? He's very committed to the rule of law. He says the fight of 1937, the court-packing fight, was not a fight to destroy the court or to impose legal limitations on its powers. The Roosevelt administration never refused obedience to any mandate of the court. Its attack on what it regarded as an abuse of power, that was what it was about, not on the institution itself. Okay, so again, rule of law, but the court has to know its place. But this was all, get the court out of the way of what the president wants to do. Okay, so before he became a judge on that court, he really thought the Supreme Court should limit itself to a very narrow reading of the Constitution. At the time, Congress was with the president, passing a lot of legislation, and the court was standing in the way. Okay, but then, as war started to loom in Europe, then the roles got reversed. So what happened was that suddenly Congress, which had supported Roosevelt until that time, became isolationist. And Congress started interfering with what Roosevelt wanted to do. And so Jackson, now Solicitor General and Attorney General, now switched to saying, Congress, get out of our way. Okay, and how did he do this? Well, Congress passed a whole series of laws in the 1930s, watching the looming crisis in Europe, series of neutrality acts. 1935, the first Neutrality Act passed by Congress prohibits the export of arms, ammunitions, and implements of war. 1936, the second Neutrality Act bars Americans from extending any loans to belligerent nations. 1937, the third Neutrality Act, American merchant ships are prevented from transporting arms to belligerents, and allowing allies to buy anything but arms can only be done if they pay cash. 1939, okay, this is when Nazi Germany is going to invade Poland and then run its way through Western Europe. 1939, Roosevelt goes to Congress and says, look, we have to aid our allies, and we have to be prepared for this war. You've got to give up these neutrality acts. And Congress is like, no, we're not getting involved. Okay, so through this time, Roosevelt's talking to Jackson and says, like, we still need to do something. Congress is saying no, but we still need to act. Okay, and so what can we do? So Jackson makes a list of more than 100 provisions of federal law that give the president various kinds of emergency powers to work his way around the strict, they're not violating what Congress said. They're just kind of evading it, right? Going around it, trying to do other things. The most audacious part of this was when Roosevelt wanted to send ships to Britain in particular, starting with mosquito boats. I actually don't know what a mosquito boat is, but I think they're smaller than what eventually comes. Roosevelt wants to send destroyers. Clearly, this sounds like a violation of the Neutrality Act, also a violation of the Espionage Act. That's another story. But the point is, Congress had basically said, we're not getting involved, and Roosevelt is like, we have to help our allies. So Jackson finally writes a memo, especially in this destroyers case, an opinion that you could tell Jackson himself was not fully into, but, again, believes that if the president's elected and this is what the public wants, then Congress should not stand in the way. In other words, just like what Jackson did with the Supreme Court, stay out of the way, we're coming, right? We've got an electoral mandate, president's got to be able to do what he was elected to do. Then he turns on Congress and basically doesn't ever, just like they never violated a direct order of the Supreme Court, he's not going to directly violate any of the neutrality acts. But they're going to find ways around this, right? And finally, Congress comes around, passes the so-called Lend-Lease law, which allows boats and other armaments to be lent to our allies in exchange for military base rights and so forth, that Congress finally kind of gives in. Jackson approves of a clause that Congress adds to that Lend-Lease that basically says, and we can revoke the presidential powers to do this at any time. Roosevelt disagrees. There's actually a great law review article Jackson writes after the war about their disagreement, but Jackson's trying to keep the president not directly violating an act of Congress. But the point here is basically to say Jackson was finding ways to expand presidential power over congressional objections, just as he was trying to find ways to expand presidential power over the court's objections. And in 1941, he writes this executive order, which authorizes Roosevelt to seize an aircraft manufacturing plant in California, which is threatening to go on strike. The idea is that we might need airplanes for this war. This is before Pearl Harbor, so the U.S. had not yet entered a war. Roosevelt seizes the aircraft manufacturing plant in the face of a labor action to keep production going. All right, so why expand presidential power? So a lot of the writing about this focuses on the fact that Jackson was just a fan of Roosevelt's. I mean, he really was. And in fact, John behind me here has edited Jackson's words left unfinished into this wonderful book called That Man, which is Jackson's portrait of Roosevelt. But here's something from a speech that Jackson gave in 1938 when he says, "Heroic periods of history, when great things are in the making, are never easy on the nerves of all the participants." So we can think about today, okay. And then, in every difficulty, there has emerged among us a leader who embodies the inarticulate instinct of the time, a leader who is magnetic enough to galvanize into a single current all of the best impulses of his generation. Such a debt as we acknowledge to Washington, Jefferson, Jackson, and Lincoln, future generations, yes, even our own generation, will acknowledge to Franklin D. Roosevelt. Okay, so he's really on board with Roosevelt the person. And eventually, actually, Jackson was one of the people who spearheaded the movement to renominate Roosevelt for unprecedented third term of office. So Jackson's clearly on board with Roosevelt, okay? But I think there's something more theoretical going on here, and that is if you, in the Struggle for Judicial Supremacy, the book where he attacks the Supreme Court, Jackson gives you another reason for being behind the expansion of presidential power. And he says here, quote, "The measure," I'm quoting him a lot because his words are so great, but also so that you know that he really said it. Okay, so here's what Jackson says about presidential power. He says, "The measure of success of a democratic system is found in the degree to which its elections really reflect rising discontent before it becomes unmanageable, by which government responds to it with timely redress, and by which losing groups are self-disciplined to accept election results. The very ability of democracies to settle issues peaceably may depend on responding to them before they have developed the bitterness which comes of long-endured injustices." In other words, Jackson's not on board just to create a dictator, right? He's on board because he says there are these crises. People have wanted something. If we don't respond, something worse happens. And I think already he's looking out of the corner of his eye at fascism rising in Europe, at what's happening when when discontent cannot be managed through elections, when governments simply can't cope. And so I think he's also got this more democratic reason for saying, we need to solve the problems now, Roosevelt's your guy, and let's go with it. Okay, so then, as you heard, he gets onto the Supreme Court, and a few years into his term, now President Truman asks Jackson to go to Nuremberg and to become the lead prosecutor of the German war criminals there. Jackson thinks he can do it over a summer. He doesn't realize that actually they haven't even set up the tribunal yet, or its rules, or its governing procedures. It turns out to be an 18-month assignment where he's AWOL from the Supreme Court, again annoying his colleagues because all the work he would have done falls to them. he didn't always have such great relations with his colleagues at the Supreme Court, but still, he takes the assignment and he winds up in Nuremberg. And the first Nuremberg trial, so the war ends, the European war ends in May. The Nuremberg trial, the first Nuremberg trial of the leaders, the dominant folks they've got in custody. Of course, Hitler has killed himself, so he's not in the dock. But his designated successor, Hermann Goering, and a lot of the other Nazi war leaders are there. The trial opens in November 1945. If any of you are lawyers in this room, you will know that if the evidence only becomes available in May to launch a trial of this magnitude in a few months like that, by November, was just a heroic task, especially since the Nuremberg, especially this first tribunal, there were 4 Allied powers, each of whom provided a prosecutor and a judge. So the U.S. was running the trial jointly with the UK, France, and the Soviet Union, the Allied powers who had won the war. And there were 22 defendants in the dock. They were facing up to 4 charges each of war crimes, crimes against humanity, what was then called crimes against peace, which we now call crime of aggression, and conspiracy to commit those crimes. Okay, now, this was controversial because the crime of conspiracy, actually, we all know, I mean, if you have followed U.S. law, you'll know people are charged with conspiracy all the time. It's a very common offense prosecuted in the United States. It is almost unheard of everywhere else. And that is because in most legal systems, they sort of say, it's one thing to sit around talking about something, but until you've actually done something, you haven't committed a crime. Okay, so conspiracy was a very controversial charge. Jackson argued very hard for it to be one of the charges at Nuremberg. It is the charge, by the way, in the end that the fewest defendants were convicted of, because I think it was really hard to persuade the judges from France and the Soviet Union that this was actually a crime. Even the UK judge was probably suspicious. But the reason why I mention this was that was the charge that Jackson took. So there are 4 charges, there are 4 countries, each country takes a charge, right? And Jackson takes conspiracy. And in the conspiracy charge, what he has to focus on is the evidence tending to show that there was actually a broad-scale plan of the functioning German government to carry out all of these activities. And so he's focused on how does the government work. Okay, now Jackson opens the trial. He convinces everybody after the indictment's read, he's the first guy up. Okay, and so he argues that the Nazi crimes were so grave that they had awakened, actually the title I gave this lecture, they had awakened, quote, the sleeping strength of imperiled civilization. In other words, what the Nazis were doing mobilized this massive war effort to win the war against them, but also this massive law effort, right, to actually bring the perpetrators to justice for the first time after a major conflict. But the people in the dock were not the people who had committed murder with bare hands. They had organized for other people to do it. And so the question is, how did you reach the leadership if they, in fact, did not actually carry out physically with their own hands those crimes? This was why conspiracy, Jackson thought, had to be part of the mix. And so he says, and I quote him from his opening statement, "The common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched." Okay, in other words, no man is above the law, right? And in fact, he says, quoting from his Nuremberg opening statement, "We are able to do away with domestic tyranny and violence and aggression by those in power against the rights of their own people only when we make all men answerable to the law." You should read the whole statement. I would just do a dramatic reading if this were a different kind of, I do this with my class. If anybody's watching on the video, you've heard me do that before. Okay, so he's compiling the evidence that there is a conspiracy, that that you have to go after the top people because the stuff at the bottom wouldn't have happened without them. So he focuses on the evils of the Nazi Party. The Nazi Party was, as he puts it, bound by an iron discipline into a pyramid with the Führer, Adolf Hitler, at the top, broadening into numerous leadership corps composed of overlords and a very extensive party membership at the base. And then here's what's crucial for him. He said, we find at this period two governments in Germany, the real and the ostensible. The forms of the German public were maintained for a time. There's still a parliament, there's still courts, there's still, it looks like you've got the constitutional system still in place. It was the outward and visible government. But the real authority in the state was outside and above the law and rested in the leadership corps of the Nazi Party. That's the conspiracy, right? And that the whole thing was held together by having this appearance of government and then this real government working side by side. All right. So he focuses, when he starts to actually engage in his cross-examination, he has a famous kind of 3-day cross-examination of Hermann Goering, who is not only Hitler's designated successor, but also head of the Gestapo. And my favorite moment from all of that cross-examination was Jackson asked Goering, upon coming to power, you immediately abolished parliamentary government in Germany? And Goering says, we found it to be no longer necessary. Okay, so in the end at Nuremberg, 22 defendants, 12 were sentenced to hang, 3 were sentenced to life in prison, 4 received sentences of 10 to 20 years, and 3 were acquitted. Jackson comes back, publishes a lot of his statements and speeches at Nuremberg in a book called The Nuremberg Trial. You can still find it. And in the preface of that book, coming back to the United States, what he says is, quote, Americans ought to be taught to recognize the early symptoms of such trends, for they can be checked only in their incipient stages. Okay? So then he comes back to the court. Now there's a lot. Again, this could be a whole course, but I'm not just going to do one lecture, right? So I'm just going to fast forward to the Youngstown case, okay? Now, this comes up to the court in 1952. Jackson is back. He's on the court. This was a case that arose in the context of the Korean War. North Korea had invaded South Korea in 1950. The brand new UN Security Council calls upon invading troops to cease hostilities. And when they didn't, the UN called on all members of the United Nations to enforce the resolution. This is the basis on which Truman sends troops to Korea. The US enters the war in June of 1950 until an armistice ends the conflict in July of 1953. In April of 1952, US steel workers decide to call a labor action paralyzing all of the steel mills in the United States. And Truman issues an executive order directing the Secretary of Commerce to seize and operate the nation's steel mills so that the production of weapons doesn't stop. You need steel for the weapons they were all using in the war. And here's the interesting Jackson little note. The order was a copy-paste of the order that Jackson had written for Roosevelt to seize the California aircraft manufacturing plant in 1941. They just crossed out aircraft California, stuck in steel mills. Otherwise, it was the same order, the same legal reasoning. Okay, and this comes up to the Supreme Court. It comes up really fast. So the union calls for a strike on the 4th of April, 1952. The president issues an executive order a few hours later. The case gets to the Supreme Court by May 12th. Okay, so just about a month from, goes through all the procedure, gets to the court. That's when oral argument is, so all the briefing even happened before that. The court issues its decision on the 2nd of June, 1952, which is to say it's very fast. It's faster than Trump v. US, which we'll get to later. Okay, so the court, by 6-3, finds that the president has no authority to take this action. There are 5 concurring opinions, there's 1 dissent, and Jackson votes with the majority to limit presidential power. Which is to say, he had changed his mind, right? And in fact, some of his fellow judges, you can see it if you read through all the footnotes and the whole opinion, some of his fellow judges are like, what is he doing sitting on this court when we're judging the thing he wrote when he was Attorney General, right? So it looks like a bit of a conflict of interest. But Jackson changes his mind, okay? Now, what does the court decide this? So, the court looks at this and says, this is Justice Black writing for the court, says the president's power, if any, to issue this order must stem either from an act of Congress or from the Constitution. There's no statute that authorizes this. Presidential war powers, he cannot use as commander-in-chief power to seize private property. He's usurped legislative authority. He's like making law. No. Okay, so Black says no. But Nancy Mavidi, who's a political scientist, has this idea where she calls it the choral court, like where there's not just one opinion. Like this one had the opinion for the court, there are 5 concurrences, there's a dissent, but what's interesting when you read the whole thing, I think they probably had so many opinions because when you write that fast, you don't have the time to actually agree on everything. But what you see is that the other justices on this court, Justice Frankfurter, by the way, who had been born in Austria, so he was completely aware of what was happening in Europe, says, for them, the founders, the framers, the doctrine of separation of powers was not mere theory, it was a felt necessity, which is you've got to put a limit on presidential power. Justice William O. Douglas, who was also on the court at that time, said, look, separation of powers is not about efficiency. It's about preventing the arbitrary use of power. And he addresses head-on the moving fast thing, like this is a crisis, we've got to act now. He says, this is Douglas, stalemates may occur when emergencies mount and the nation suffers for lack of harmonious reciprocal action between the White House and Capitol Hill. That's a risk inherent in our system. In other words, sometimes you just have to wait, okay? And Justice Burton and Clark also write concurrences, I won't go through them. The dissent by Chief Justice Vinson with Justices Reed and Minton says, wait a second, Truman told Congress he was going to do this. He gave them 12 days to say, don't do it. And they didn't act. Moreover, Hamilton, Federalist 70, says the executive is meant to have energy, power, and independence. And besides, Roosevelt did the exact same thing, right? Like, we're just making this up. Like, nobody challenged Roosevelt. And in fact, it wasn't just that Roosevelt had seized the California aircraft, but they had seized a whole bunch of things during the war, including my favorite, Montgomery Ward. I'm so glad, I have to explain to my students what Montgomery Ward is. Okay, so they had seized all kinds of stuff during World War II, like since when did we decide this was not something they could do? And Robert Jackson had written the opinion, and what's he doing on the other side? Okay, so I come to Robert Jackson's concurrence, because it's a concurrence. For those of you who know how these things work, a concurrence is not binding law, okay? But it has been the main reason why everybody reads Youngstown. And Jackson's framing of this issue I think, has been the dominant way to think about separation of powers, like, ever since. And so Jackson says, he starts by kind of admitting his own position. You heard from John that he's a bit autobiographical sometimes in his opinions. He says that comprehensive and undefined presidential powers hold both practical advantages and grave dangers for the country, will impress anyone who has served as legal advisor to a president in times of transition and public anxiety, right? Like, I've been there. All right, and so then he says, the tendency is strong to emphasize immediate results, but one should not, quote, lose sight of enduring consequences upon the balanced power structure of the republic, right? And so he then says, so how do we think about this? And so what the opinion's famous for is he says there are 3 different buckets, like, into which we have to put the exercise of presidential power. Bucket 1, when the president, quote, when the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all he possesses in his own right, plus Congress's delegation. So if they tell him to do it, great. Bucket 2, when the president acts in the absence of either a congressional grant or denial of authority, he can rely only on his own independent powers, but there is a zone of twilight in which he and Congress may have concurrent authority, or its distribution is uncertain, right? So there may be sort of a genuine question. Then he basically says it's going to depend on the facts, okay? So there's going to be this zone where they fight it out. But then, bucket 3, which is where he thinks this case belongs, when the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. For then he can only rely upon his own constitutional powers, minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control in such a case only by disabling Congress from acting upon the subject. So when would a court do that? Presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. In other words, if Congress has said no, the president should take no for an answer, and courts should not somehow give the president the right to just blow past what Congress has said, right? Bucket 3. He said, later he says, the purpose of the Constitution is not just to grant power, but to keep it from getting out of hand. Right? He said the framers knew what emergencies were. They knew the pressures they engender for authoritative action. They knew, too, how they afford a ready pretext for usurpation. We may also suspect that they suspected that emergency powers would tend to kindle emergencies. Right? In other words, if you have to act fast, if you're going to blow past what Congress has said, this is like danger zone, and we have to rein the president in. And then, this is the part, if you've ever been to law school, if you've ever read this case, they edit out all the good stuff, okay? Just one paragraph. Germany, after the First World War, framed the Weimar Constitution designed to secure her liberties in the Western tradition. However, the President of the Republic, without concurrence of the Reichstag, the parliament, was empowered temporarily to suspend any or all individual rights if the public safety and order were seriously disturbed or endangered. This proved a temptation to every government, whatever its shade of opinion, and in 13 years, suspension of rights was invoked on more than 250 occasions. Finally, Hitler persuaded President von Hindenburg to suspend all such rights, and they were never restored. This is the Nuremberg Jackson, right? And then he says, look, in France and Britain, emergency powers stay with the parliament. They're never just given to the executive. You have to have parliamentary control, especially in emergencies. And so he says, emergency powers are consistent with free government only when their control is lodged elsewhere than in the executive who exercises them. In other words, Jackson has really come around, right? This is not the Jackson that says, Supreme Court, get out of the way, the president's been elected. Congress, you guys don't know what you're doing with these neutrality acts, we're going to barrel forward, right? This is Jackson who says, I've seen what this can do. And I'm coming back and telling you, like, this is not what a court should do. All right. So this is Jackson changing his mind. He advocates for a constrained presidency. And one of my favorite Jackson quotes comes from an entirely different opinion, Massachusetts versus the United States, too technical to even tell you what it's about. But he says there, this is from 1948, so post-Nuremberg, Jackson says, I see no reason why I should be consciously wrong today because I was unconsciously wrong yesterday. Okay, so now let me fast forward. I promised you a little bit about now. I'm going to fast forward to our current Supreme Court, which, like I said, I don't normally talk about. But the Supreme Court is now confronting the question of what do we do with separation of powers, with presidential powers that are being claimed to be very extensive. And so what is the court doing about it? So as I get into it, let me just say, this is the part where I hope there's some diversity of political view in the audience, right? But I want to say there's a difference between politics of left and right, where as a country we're divided almost down the middle and where every election is on a knife edge. That's one kind of politics. I want to talk about a different kind of politics, which is what kind of regime do we have? Do we have a democracy or a dictatorship? That's a different conversation. And actually what's interesting is when you look at American public opinion, if you ask left-right kind of questions, the public is just divided in the middle. If you ask this question, so would a strong leader that can make decisions without interference from Parliament or the courts be a good idea or a bad idea? Okay, and that, you've got 72% of the American public says it would be a bad idea for a strong leader to operate without. Now, of course, in the US, we're between a quarter and a third of the public who answers that question positively, and that's higher than other democracies right now. But on that question, do we want a dictatorship or a democracy? We're not so divided as a country, and that's the kind of politics I want to talk about now. Democracy, where you have, it's not about whether the current person was elected, it's about whether you can get to future free and fair elections and rotate power peacefully. When you're in a dictatorship, power cannot rotate, even if you have elections where power is concentrated in a few hands. All right, so let me come back to the Supreme Court. So again, separation of powers is really on the table. So some of you may remember that when our now president was a former president, he was indicted by special counsel Jack Smith for a plot to overturn the results of the 2020 election. The case that grew out of that, Trump argued that he was immune from criminal prosecution because anything he did as president, he said, could not be criminally prosecuted. Virtually every expert who looked at that, and this is Kate Shaw's lecture from last year, so I will just refer to that. It's on video. It's very good. That basically everyone thought that was a crazy argument. And the trial court said, crazy argument. The Court of Appeals said, crazy argument. It goes up to the Supreme Court. They sit on it for a very long time. When they finally come down with their decision on July 1st of last year, the court finds in a sweeping decision that former presidents, current presidents, have immunity for virtually anything they do in their role as president. Sweeping absolute immunity in cases where they are acting within the core of their duties, and presumptive immunity for everything else. And the court also found that even if a president is indicted for something they do in their completely private capacity, evidence that actually comes from anything they did as president cannot be introduced in the trial, even of private wrongs. This was way more than Trump had even asked for. But the reason why I want to mention that is that here's where we are back in separation of powers, where Trump now is president, and he's claiming broad powers. But here's what the Supreme Court said in that Trump versus United States case before the last election. It cites Youngstown. It cites Jackson. Here's what Justice Roberts says. No matter the context, the president's authority to act necessarily stems from an act of Congress or the Constitution itself, citing Youngstown. You just heard me say that. The majority opinion says his authority has to come from the Constitution or a statute. Fine. In the latter case, the president's authority is sometimes conclusive and preclusive, citing Jackson. Yes, he says those words. Okay. When the president exercises such an authority, this is Justice Roberts in Trump v. U.S., when the president exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. Not really Jackson. He cites Jackson. Okay. The exclusive constitutional authority of the president, quote, disables the Congress from acting upon the subject, citing Jackson. And the courts have, quote, no power to control the president's discretion when he acts pursuant to the powers invested in him exclusively by the Constitution, citing Marbury versus Madison. Let me just recall what Jackson said. Here's what Jackson says in bucket 3, right? When the president takes measures incompatible with the expressed or implied will of the Congress, his power is at its lowest ebb. For then he can rely only upon his own constitutional powers. Courts can sustain such exclusive presidential control only by disabling the Congress, but, and this is the crucial sentence, right? Presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. The Roberts opinion quotes little phrases from that excerpt and turns them on its head. It says, if Congress acts, the president can act even if Congress has said no, and the courts cannot say anything about it. Okay? They go on. Congress cannot act on and courts cannot examine the president's action on subjects within his conclusive and preclusive authority, citing Jackson. Really? That's exactly the opposite of what Jackson said. It follows that an act of Congress, this is Roberts, either a specific one targeted at the president or a generally applicable one, may not criminalize the president's action within his exclusive constitutional powers. Let me quote you from Jackson at Nuremberg. We are able to do away with domestic tyranny and violence and aggression by those in power against the rights of their own people only when we make all men answerable to the law. It could not be more opposite what Jackson learned at Nuremberg and what I think he was saying in Youngstown, right? It's exactly that emergency dictator, the president must be effective, the president must act without checks, that the Supreme Court has just overturned in Trump v. U.S. So let me fast forward now to this last term that we've just been through of the Supreme Court. The Supreme Court's immunity decision basically meant that Trump did not stand trial for the attempt to overthrow the election. He's then, of course, elected in a close election. He's inaugurated on January 20th, and he immediately begins issuing executive orders that obviously conflict with existing statutes and with prevailing interpretations of the Constitution. Now, an executive order actually cannot override a statute or the Constitution. This is like law school first day. And so, as a result, there are, as of this past weekend, 373 lawsuits that have been brought challenging these executive orders. That doesn't, by the way, count the individual immigration cases. Those are just kind of the structural, no, you can't do this, separation of powers type cases. And so what we're finding is that the lower courts have almost uniformly said to the president, no, what you're doing conflicts with the statute. Remember back to if Congress has said no, no, you can't. Conflicts with the statute, conflicts with existing interpretation of the Constitution. This has been really just widespread. So like 80% of the cases, the courts have been saying, no, you can't do this. Okay, and then only a few of those Trump has taken up to the Supreme Court. Now, we don't have any, it takes a while for a case to really get to the Supreme Court on, as we say, the merits, which is to say, what's the right answer to this question? Can he do it? The way these cases have come up to the Supreme Court is that the lower courts are issuing injunctions, which is, no, the executive order can't be enforced until we sort this out, and we're going to keep the status quo in place until we figure it out. That's what the lower courts are saying. Okay? And then it goes up on speed dial, as Ketanji Brown Jackson said. It goes up on speed dial to the Supreme Court, and the question that comes up to the court is, does the injunction stay in place, or is the injunction lifted? In other words, can the president do this stuff until we figure it out, or do you keep the status quo? Okay, now there have been 18 such cases involving the wisdom of these injunctions, and in all 18, the Supreme Court has lifted the injunctions. Okay, now what does that mean? What it means is that the standard for an injunction, it has it built into it, whether you think the party that's bringing the case is going to win or not. And basically what the courts are doing, they haven't examined everything. It's provisional, it's temporary, but what the courts are saying is, looking at the law, looking at the claim, we're going to keep the party that we think is going to win in possession of their rights. So if the plaintiff is going to win, you let the plaintiff keep the injunction. If you think the defendant is going to win, you let the defendant go ahead. And in other words, you sort of anticipate the outcome. The Supreme Court is lifting the injunctions. That means they think the president's going to win, even if they haven't reached a final decision. So what has the Supreme Court done? It has, first of all, blocked nationwide injunctions to stop executive orders. This is the Bain tool that has been happening, which is you go into court and you say the president can't do this anywhere in the country, or to anyone in the country, even if there's only a handful of plaintiffs before the court. Court said you can't do it that way, you got to bring them as individual cases. They made it very hard to stop the presidential orders. They've allowed the president to fire heads of executive branch agencies that have been protected by laws since the New Deal. All right. They've allowed the president to mass fire civil servants in what are called RIFs, reductions in force. Yes, there are statutory provisions that permit it. The conditions under which you would have them permitted do not seem, to most of us, to have been met. They've allowed the president to dismantle whole executive branch agencies, CUSAID, the Department of Education, despite statutes of Congress saying these things exist and the president must enforce them. They've allowed the president to extract and remove non-citizens to third countries where they might be tortured or mistreated without any hearing. Now, the first two cases, the Supreme Court said, you've got to have a hearing. Then there was a third case where without any decision, they just said, go ahead and send them even if there's no hearing. All right, they've required individual habeas hearings for each person unlawfully detained instead of allowing lawyers to go in and say, no one can be detained under these circumstances, which would make it a lot easier to stop it. Now, each individual person has to find a lawyer in the 5 minutes between when they're whisked off the streets and when they're taken out of the country, and on and on. Every single case, the Supreme Court has allowed the president to move forward. which tells you that they think the president's going to win. Okay, now, and there's two more cases that just went up last week. We don't have an answer yet. One is whether there's an injunction now in Los Angeles where the president has, deployed the National Guard and Marines, but where the ICE agents who were picking people off the streets have literally admitted in court that it's enough if somebody looks foreign, speaks a foreign language. They're sort of profiling, which is exactly what the Fourth Amendment to the United States, as we've understood it till now, says the police cannot do. So there's a very powerful district court decision, appeals court decision, that says, no, you can't do that. And now they've taken that up to the Supreme Court last week. There's another case involving the cutback of all these science grants, something like $1.8 billion in federal science grants. Lower court judge said you can't just cut the contracts in the middle of a contract without any reason, reinstate the funding. They've taken that one up too. So those are two that are going to come out probably in the next week or two. All right, so where are we? Where we are now is moving very fast toward what my invisible co-author, Andrew Weissman, calls not unitary executive, but unitary government. It's about the collapse of separation of powers into the powers of the presidency. And all of this is happening by executive order. The Supreme Court this time is on board. It's like the opposite of what we saw in the New Deal. And Congress is asleep. So let me just close by saying, now what? Okay, so for those of us like me who have been mostly working outside the United States the last several decades, we have seen this happen elsewhere. This is what I've seen in Viktor Orban's Hungary. In fact, Viktor Orban was actually involved in writing Project 2025. A lot of what's happening now is exactly what I walked through since 2010 in Hungary. Similarities to what happened in Russia, to Venezuela, Ecuador, which sort of pulled itself back from the brink, and Turkey. This is what happens. Like when dictatorship is coming, all power collapses into executive power, and both the parliament and the courts are disabled. The civil service is squashed. Civil society lives in fear of arbitrary power, and this is how it happens. So this is where I want to say we can learn a lesson from Jackson, right? When Jackson was arguing for unlimited executive power because we're in a hurry, we have to do things, there's an emergency, we were elected, the president has a popular mandate and he has to be able to get his way. That was because Jackson had not yet been to Nuremberg. Once he goes to Nuremberg, once he sees what dictatorship looks like, he comes back and says, it doesn't matter how much of a hurry you're in. Preserving the separation of powers is much more important than simply acting on the basis of one election, or even two elections, what a president might want to do in the meantime. So this is where I want to say that this is where we also need to look abroad, like Jackson, and say, this is not about what happened at the last election. I already snuck in my definition of democracy, which is that it's not about the last election, it's about the next one. And whether you can get rotation of power, whether you have somebody who's willing to acknowledge that they've lost an election, so that the next time around, maybe there'll be a different consensus over what kind of policies there are, over what kind of government we have. Okay, and with that, I think what we need to do is to remember that the rest of the world may know more than we do in this moment, that we can learn from that, and that what Jackson taught us, right, which is that you might have that man, that president that you admire, whatever he wants to do, if it's only him, if you lose separation of powers, you lose democracy. And so I think what we need to do is honor Jackson's legacy, be very careful, be very afraid, and stay engaged. Thanks very much.
Would you be able to comment a little bit more on the Supreme Court shadow docket process? I know you touched on that a little bit, but both the impact now with deciding things on procedural rather than the merits and what that happens in the future.
Yeah. So the leading authority on shadow docket is Steve Vladeck, whose book Shadow Docket is terrific and written for non-lawyers, so I urge you all to look at that. But here's the thing. The Supreme Court has always had what is now called a shadow docket or an emergency docket. So because there are going to be cases where there's a question, mostly these procedural motions, do you keep an injunction in place or not? The other thing that, of course, that comes up on this emergency docket are death penalty last-minute appeals and so on. So the answer to this problem is not to get rid of the shadow docket. I think what a lot of us have gotten worried about in the Supreme Court's use of these emergency motions is that the reason why, 80% of the lower courts, when they hear these cases, put an injunction down is because they see that the executive order that's being challenged violates the law as of January 20th. It violates a statute or it violates existing constitutional law. And so I think what most of us would say is that the only way that existing law should be overturned like that, right, that a statute is going to be gutted, a constitutional interpretation that we've taken for granted since the New Deal, like Humphrey's executor, for the lawyers in the room, is on its way out. Those cases, it's not that the court can never change its mind. It's that if the court is going to do it, it should do it on briefing, with full argument, and with reasons when it does it. And that's not what's happening. What you're getting in what you're getting in these cases is that the Supreme Court is signaling to you that the law can no longer be relied on that you thought was solid. Now, you might not have agreed with it. Again, this is not about left-right politics, right? This is sort of about what's the role of all these institutions and how do we keep power balanced and checked. So the court might be going there, but if they're going to go there, then they should do it following a procedure where everybody is on notice that this is coming. It's done in an orderly fashion, and it's done, where the court actually has to explain itself. So, there's so many of these outrageous cases, but the one I found most outrageous was that there were these two cases that came up to the court on the emergency docket that involved the question of, can people be picked up off the streets and sent to what we call a third country? First country is where they started, second country is where they got citizenship, third country is none of those. So this is the Venezuelans who got picked up and sent to this prison in El Salvador. Shouldn't they have a hearing to determine, A, that they really are not in status in this country, and B, that they don't have we call them CAT hearings, Convention Against Torture hearings, a well-founded fear that something will happen to them if they go there. Actually, they all would have. That prison's terrible. The court said, oh, yes, they have to have hearings. Twice they said the court has to have hearings with two different versions of that case. And then they had this case where there were a bunch of people picked up. They were taken by plane. The plane had to refuel in Ireland. It refueled in Djibouti. They were being sent to South Sudan. Okay, now South Sudan's a country with functionally no government. It's so dangerous the U.S. government does not have an embassy there. And somehow, whatever the U.S. is interpreting the government of South Sudan to be, gave assurances that people could be picked up off the streets in the U.S. and sent to a prison in South Sudan. And they were on their way to being deported there with no hearing. The plane stops in Djibouti. The judge says, I don't care how you do it. You got to give them a hearing. You give them a hearing there, wherever. The government delays, doesn't give them a hearing, says we can't give them a hearing. And then it goes back up to the Supreme Court. And the Supreme Court says, okay, never mind. You can send them. Which is to say, what happened to that case they decided 2 weeks ago, which said you had to have a hearing? They haven't even explained why they changed their own mind from the Venezuela case to the South Sudan case. So it's just, we're sort of in a situation where literally, I'm really glad I'm teaching at Stanford Law School in the fall, okay, but I'm really glad I'm not teaching U.S. constitutional law or Fourth Amendment or anything, because I'm teaching something else. Because we don't know what the law is. The Supreme Court changes its mind every day with no warning and no reasons. That's why, again, I really hope, if we have a diversity of political views in the audience, that this will outrage everybody, even if you support this particular president, right? This is really lawless behavior, and that's why this is dangerous. The court will always have emergency petitions, right? We don't stop that. What we stop is this abuse of them. All right, long answer, sorry. I'll be shorter.
Thank you.
Oh, thank you. Okay.
I'm going to hit you with a little current events, very current, if you don't mind. We've gotten several audience members who must have seen the headlines.
Washington today?
Yeah.
Okay, got it.
The headline being, Trump orders National Guard to Washington and takeover of Capitol's police. Do you have any comment on this power grab in terms of constitutionality and the overall governance of Washington, D.C. and its citizens?
Yeah, okay, so first of all, there's a preview of this in what happened in Los Angeles. That's that case that's currently now up before actually there was a trial actually today on the question of what the National Guard, the federalized National Guard were doing in Los Angeles. DC is a little bit different because DC is not a state. DC is actually got limited home rule, but is a federal territory under the governance of the US Congress. So one of the questions that's going to arise here, the National Guard in DC have never been under the control of the mayor. That's why on January 6th with the insurrection, the mayor could not call out the National Guard. So the DC situation is legally a bit different than Los Angeles, okay? But what we've seen with the president calling out the National Guard in Los Angeles and now in DC, and by the way, what was also happening in DC was that they called out FBI agents to patrol the streets. Can I just tell you, FBI agents don't do that, right? They don't have any training, they don't know how to do it. Like, what are they doing? And there's a whole bunch of other police that are kind of under the control of the federal government, the Bureau of Prisons Police, the Alcohol, Tobacco, and Firearms Police. Trump has done this before, like when he broke up the Black Lives Matter protests in DC, he called out exactly this configuration of armed guys. And so they're testing the limits on overriding local authorities who are not necessarily on board with this administration. They're going to be doing it primarily in blue states, blue cities, and there's a part of this that's legal. The president can federalize the National Guards. This is not federalization because it's DC, it's a different structure, but you know, if you're from New York, which Trump said would come next, or Oakland, I think is another city he targeted in his little speech this morning. In these cities, the president would have to do what's called federalizing the National Guard. There's criteria for that, one of which is that the local police can't handle the situation. In Los Angeles, the local police, LAPD, which is not exactly a liberal-like organization, said, we've got it under control, we don't need them, and yet the president did it. So here's the question. It's going to come up as it's coming up in Los Angeles, it'll come up in DC. Are the conditions under which the president can federalize the National Guard, take the state armies, right, and put them under federal command, are the conditions met through which the president can do that? There is a way he can legally do it. The problem is that it looks like none of the conditions that have to be demonstrated for him to do that have been met. This is where the courts come in. So the courts are going to look at that and say, okay, here's the law. Has the president followed the law? In Los Angeles, where this was tried, district court said no, he hasn't. Appeals court said no, he hasn't. And the Supreme Court just got this case last week. We will be able to tell when you see the decision in the Los Angeles case, which may come out with no reasons. It may say vacate the injunction. That's all you need to know to say the Supreme Court thinks it's fine. That case will probably come out in the next week. So Trump is using these powers. He's trying to intimidate. He's trying to instill fear. He's trying to put the blue states, the blue cities, in some peril, you know, from having their local police not necessarily be on board with what the federal government's up to. But, you know, if the courts hold the line, if he follows court decisions. But, you know, we're really in that situation where I don't know what the Supreme Court's going to do. But that will be your signal when you see what they do in the Los Angeles case. And you'll know that within a week or so, I think. Yeah.
That is where we will have to leave it today. I'm so sorry.
Okay.
Chautauqua, please join me in thanking Kim, Lane Scheppele, and the Robert H. Jackson Center.